Hello, and welcome to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Van Staldeinen, and joining me is immigration lawyer Zeynab Ziaie Moayyed. Welcome, Zeynab.
Hi, Rosalie.
Zeynab, what challenges do the proposed and predicted express entry system changes pose for immigration practitioners? And how might practitioners navigate these changes?
Well, Rosalie, this is a very interesting and exciting time. Early 2020, April 2026, IRCC confirmed that there is going to be major changes and updates to the express entry system. And the current system that we have has pretty much remained the same as a legal framework for over a decade. And we have had incremental changes over this period of time, but they've mostly been done through ministerial instructions. So we've had, over the last particularly 5 years, introduction of category-based draws, French language draws, and even last year we saw the removal of job offer points. But all of these were done without having to go back and change the act or the regulation. And at this time, IRCC feels that there is enough data and enough of a need for a bit of a system overhaul. And the big change that they have announced is going to happen is that we're going to go from the current system of having three different main streams, the Canadian Experience Class, Federal Skilled Workers, and the Trades Program, to having just one overarching program and minimizing and synchronizing the requirements that applicants have to meet the minimum requirements of these programs. And I think that will help simplify things somewhat, particularly if we think about the skilled worker, where you still have to go back and calculate and make sure that applicants meet the 67 point threshold, right? But the other part that's going to be very interesting, and I think it's still very unclear, is how the CRS score system is going to change. There will continue to be some form of scoring, and the overall sort of function of the system of meeting minimum requirements, obtaining a CRS score, entering the pool, and then being selected, it appears that that's going to remain the same. But what we're going to see is a different combination of CRS scores. And it is very interesting because IRCC is trying to go and look at the economic realities of Canada today, and I think some prediction of where we might be headed in the future, as well as looking at data from the past decade or so of who have been more successful, which immigrants, based on their characteristics, have been more successful in Canada. And I have to say this again, this is very early on. All we have is some of the very early pronouncements of things that they're thinking of changing. And at the end of the day, these might be different. But as of now, based on some of the information that they've made available, we know that they're going to be changing the work experience points. And in addition to the more experience you have, the more points you have, they also want to introduce an idea of the more high wage an occupation is, potentially having higher scores. And that's supposed to track the idea of potentially some high wage positions being more high skilled. There's a lot of discussion of whether that's the right approach, particularly given the need for specific occupations such as trades and the regional needs that we have across the country. But that's certainly something that IRCC has said that they're looking at. We're very likely to go back to a system of having job offer points, some new variation of this. And I think that could kind of work hand in hand with this idea of looking at specific occupations. There are also a couple of categories of points that they're thinking of getting rid of, which is very interesting. One of them is sibling points. They were there as a recognition that if you have potentially close family in Canada, you're more likely to stay. And perhaps the data is showing that that is not a significant factor in the long-term decisions of applicants. We don't have access to that, but that's certainly something that unfortunately is on the chopping block. The other one, which is also very, I think, controversial, is getting rid of study in Canada points. this is going to negatively impact a lot of people who have spent time in Canada, whether it's a college program all the way up to a PhD, studying here. And, the education points will remain in place, but those additional points that came from having studied in Canada, which could be a great indicator of you've got to know Canada, you've established roots here, you have connections, you have specific knowledge of markets and industries, that's going to go away. And I think I would agree that that might be something that IRCC should potentially reconsider, because I think there's a lot of value in there. And finally, another one that they're very likely to get rid of is this very interesting breakdown of spousal points, right? So as the current CRS score system works, if you are a single person or you're applying without a spouse, your points are calculated in one way. But if you are with a spouse, they're calculated in a different way, and typically can be to your disadvantage unless your spouse is highly educated and also has great language ability. And in the last year and a half, 2 years, we've seen a lot of refusals based on applicants making determinations and electing to list their spouses as non-accompanying. So this change, I think, is actually probably a welcome one, because it will take that uncertainty out of the system and applicants won't be forced to choose. And I hope that at the end of the day, what IRCC does is that they look at the ways in which perhaps some of the points in the current system were open to manipulation and try to avoid that going forward. So I think the spousal point change is a very good one. So I think over the next few months, we're going to see how IRCC settles on their final determination of these CRS scores, but it will take some time because the changes will have to be to the act and regulations. So it's not going to be just through ministerial instructions. And that goes back to your part of the question, Rosalie, of how do we advise our clients and how do we sort of proceed from there? I think it's really important for us to have these conversations. Clients will, for the most part, have heard something probably by now, and many of them might even be in a bit of a panic, or there might be applicants more and more reaching out to us from outside of Canada thinking that with the changes, there might be opportunities opening up. So I think what's really important is to address the uncertainty head on, make sure that applicants know that. What we know is certain things are not going to change. So language proficiency, just having work experience in Canada, those things are not going to change. I think applicants can focus on that for now. If they are able to finalize their documentation and try to submit applications earlier, better to do that. The other thing that will help us as practitioners is thinking about our retainer agreements and how to address this uncertainty and potential changes when we sign retainers with new applicants. So most of us will already have provisions in our retainer about change in law, change in policy. This is going to be even more important if you're signing retainers now with applicants who think that they might qualify for express entry because they're going to meet their 1 year of Canadian experience in the next few months. Well, I think, based on the current circumstances, you might agree to something, but you would want to have something in your retainer to ensure that if there are system changes, you've already had that conversation with the client, they're aware, and that you might have to go and revisit both their eligibility and what your services would include, because there might be other structural changes. At the end of the day, we're going to have to keep tabs on how things are developing. There's going to be changes coming, and I'm sure that we will learn more in the coming months and we'll be able to better advise our clients.
Wonderful. Well, thank you very much, Zeynab, for updating us on these ongoing developments and also providing some insight into how practitioners might respond to these challenges. Thank you very much.
You're welcome.
Let's talk again.